All rise. The Court of Appeals Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in SACHS against SACHS, our cause number 1CACV 15-0645. Counsel, as I'm sure you're aware, the court has reviewed the briefing carefully and is familiar with the issues in the case. So you can bear that in mind as you begin your presentation. I should let you know that we're being audio and video recorded today. The recording of the argument will be made publicly available online. Each side will have 20 minutes for oral argument. The appellant may reserve as much time as you wish for rebuttal, but you're responsible for watching your own clock. And with that, we may begin.
Good morning, Your Honor. Good morning. My name is M. Philip Escolar, and I represent the respondent and appellant in this action, Mr. Kenneth SACHS, who is present here and seated in the gallery. And in light of what the court announced at the beginning of this hearing, if it pleases the court, I'd like to then skip making a statement of the case and the facts and proceed right to essentially the heart of what we wanted to focus on today in this oral argument, and for that matter, what we requested the oral argument for. Naturally, I do wish to reserve several minutes for rebuttal, and I do understand that it is my responsibility to keep track of time. With that said, in our limited view as litigants in this case, we do feel that the issues generally were really briefed well by the parties. We took our best shot, they took their best shot, and as a general matter, we definitely stand on our briefs. And I don't have anything in particular to say with respect to twisting or expanding anything in the briefs, not that that would be permissible anyway. But we do wish to discuss a few things that we think are particularly helpful regarding the proper way to conceptualize and think about the claims in the appeal we have made here. We believe that the trial judge, as a general matter, had a very interesting and even commendable initial strategy on how to assist the parties in adjudicating their disputes with respect to the premarital agreement in question. More specifically, in March of 2014, the parties had just resolved many of the issues that in most family cases are often the most contentious. Child support, parenting time, legal decision-making, and so forth. So when that parenting plan was presented to the court on the same day at a status conference, the court noted, well, there really seems to be really only one major issue in dispute: the enforceability of this premarital agreement. And then the court instituted a briefing schedule, a bifurcated briefing schedule, if you will, on two different issues. One was whether or not mother was entitled to the $175,000 cash payout that is in Section 4A of the premarital agreement. And then the other issue was whether or not mother was entitled to some award based on a provision that purported to award a marital residence to mother. Excuse me. So when, at this status conference, when the court set its briefing schedule, it didn't necessarily specify what legal standard was going to be in play. And I mention that now, I'm going to come back to it in just a minute, but I think it's really important that we note right at that time the court just simply set a briefing schedule, and that can be seen in the appropriate minute entry in the record. So at the time when the court did set the briefing schedule, it did seem to make pretty good sense to us, and I believe the other party as well, because you can certainly conceive of many instances where a trial court can properly adjudicate a contractual dispute as a matter of law. However, as appellant began to brief his positions with respect to the $175K cash payout provision, he quickly noticed that the trial court was probably going to need an evidentiary hearing.
For what?
If I could jump ahead then to mention the O'Daniel case. In the O'Daniel case, which is a Tennessee case that we think is the seminal case on the public charge exception, the trial court heard a lot of evidence, because there's two pieces of the puzzle. One would be what's the cash position and the asset position of the person claiming the public charge exception. The other piece of the puzzle is what are the likely expenses and expenditures as medically necessary that could, in the end, depending on how it balances out, make it likely that that particular person was going to be a public charge owner. So we believed at the time, even in our opening brief, that an evidentiary hearing.
But what would you have presented at an evidentiary hearing?
Most likely, we would have interviewed, obtained, secured, and disclosed, and eventually garnered the testimony of specific medical and possibly financial experts with respect to forecasting what sort of expenses father would have given the conditions we would have. In other words, we would probably try to follow the O'Daniel map in terms of finding the appropriate kind of expert, whether percipient or just regular experts, that could forecast with some degree of certainty the type of expenses that Mr. Sachs would face.
Is there anyone you can think of who is not likely to face significant expenses as they age?
I can't think of anyone.
Right. And so if it's simply a case of, yeah, I have the money now, but I may not have it later because I'm going to get old and I may need medical help, that would pretty much gut the enforceability of every prenuptial agreement, wouldn't it?
And I think it could. It could. It would be fact-dependent on each of the circumstances. For instance, if a person without significant maladies, they'll likely still face
We're all going to
significant
get
medical
significant
expenses.
maladies at some point.
That's correct. Now, interestingly, with someone who already has those significant maladies, it seems logical to expect that their particular expenses will at least have a little more predictability than someone who has none whatsoever.
Is that the standard?
If those reasonably foreseeable medical expenses clearly, or I don't even know if that's the standard, just make it likely that those expenses will outweigh what that particular person will have available to them, I do think then that is the standard. That seemed to be the standard, I believe, Your Honor, in O'Daniel.
I don't mean to beat this horse,
Sure.
but I think if you asked an insurance actuary how many of us would likely have the independent resources to cover our maladies in our dotage, they would say a very small percentage of us could actually fund the cost of our own health care as we age, right?
That's true, Your Honor.
And so if that's the evidence, then are you saying that the Tennessee law allowing enforcement of prenuptial agreements applies only to a tiny percentage of Tennesseans?
I don't believe so, Your Honor. Without having the data available at hand, and without a doubt, everything Your Honor said is true. There's probably a relatively small percentage of people that can handle their expenses, reasonably forecastable expenses, as they age. But in particular, when that person does happen to have the ability to perhaps handle those expenses, and we contend father is exactly one of those people, then the law takes the view of, well, perhaps this is one of the few that does not need to be put on the public dole. The marital community's responsibility, as we dissolve it, is to its parties.
What is the public dole? I mean, the whole public charge notion sounds rather antique. I'm not aware of a dole. Is there a place I can apply? Because I haven't. I apart from sort of the baseline federal health insurance programs and Social Security, what other dole is there?
Yeah, and that's the opportunity we were, I believe, prevented from presenting to the trial court. There are a bevy of programs that are need-based. I think that much can at least be accepted. The very specific ones...
Give us a taste.
Medically based ones, certain Medicare, Medicaid programs, the need-based ones, that is. He's already on one of them, which is in part need-based, which is Social Security and disability insurance. He's already on that, but he was prevented from at least presenting a list of those to the court, and beyond just a list, expert testimony stating he would likely need these particular programs.
But counsel, in your pleadings, in your briefing, you said, you told the court, we want to present experts, and these experts will say A, B, C, and D, and we want to present this type of detail that you're giving us now. Did you raise it to the same?
Not to that same level of detail, Your Honor, no. Not to that particular detail, just that we would want an evidentiary hearing, given what we, as soon as we started researching and drafting motions to apply the public charge exception, we did at least state that we would need an evidentiary hearing to present the proper evidence. I guess what I'm saying, Your Honor, is we implied that. Because I think he already gave an affidavit in his original motion. So the fact that we wanted to present additional evidence, I believe that just implies that we would present competent additional evidence to support his claim.
The wife didn't dispute that your client had these maladies, and there was really not a lot of dispute about the. I think the trial court used your figures in determining what the amounts were going to be available to him, what he had available to him on a monthly basis now, that the disability insurance was going to be available for him for another 10 years. It was 11 at the time of the trial. I think it's less than 10 years now. So, I mean, all that information, the trial court used your figures. Wouldn't you agree with me?
I would completely agree with you, Your Honor. In fact, I believe that's what the trial court did to kind of, and the logic of it is appreciated, to cut to the heart of the matter and say, I can resolve this by resolving the conflicting inferences in favor of father with respect to income and net worth, since in the pleadings themselves there was some dispute. So by using father's figures of $348K, I believe, and his income figures as set for so many years, I believe the trial court felt, there, I've resolved the conflicting inferences. But it didn't. It only resolved one piece of the puzzle. Because as the O'Daniel case, and I think logic itself dictates, there are two pieces to the puzzle. The potential expenses, which were very much focused on in the O'Daniel case, as well as the fixed or agreed upon net worth figures. Those were agreed upon in O'Daniel as well. She had $268,000 in assets, 67 months of health insurance, and the ability to work, to boot. And yet they still found her to likely to be a public charge when the insurance and medical testimony was presented with respect to her possible or likely future expenses. So I believe it did resolve the left side, so to speak, Your Honor, but not the right side of the equation. And noting time slipping away from me, I should note that we have other theories and other claims in this appeal, and I would like to say the fact that I'm not specifically discussing them doesn't mean we intend to throw them away. In fact, we very much believe in everything in our brief, but I still want to, if I could, go back to the 175K and the briefing issue, because I would like to emphasize, to the extent that not enough evidence was presented, we do want to make our argument clear to the court that we feel that we just did not have the opportunity to present it. There was just a 20-day window from when the court set the briefing schedule to when our first brief was due. And under many circumstances, that would probably be okay. For instance, if it was just a matter of determining whether the public charge exception is a viable doctrine, a question of law, sure, I think we could have briefed that just fine. But when it comes down to whether or not it applies to this particular case, I don't believe we had the opportunity. I don't believe even under a motion for summary judgment standard, you get 30 days. And that doesn't even necessarily anticipate a big launch of expert witnesses. It just analyzes whether there is a question of fact or not that would require a further trial or evidentiary, and that's what we believe happened here. We at least presented genuine issues of material fact. The trial court didn't specify what standard we were operating under, so we're kind of assuming it would have been a motion for summary judgment. And that said, we think we made at least the prima facie showing that even with his fixed income at $348K and his income that he was receiving until age 65, the fact that he was going to lose so much of that income, coupled with his existing and indisputable disability and maladies, at least presented, and not to mention he did make at least the bare allegations that he was incurring and would incur significant medical expenses. That should have sent this to an evidentiary hearing, Your Honor.
Besides the request in your opening brief for an evidentiary hearing after the court ruled, did you ever make that request again?
To the trial court, no. We mentioned in our opening brief, of course, in our reply brief here, but I'm not really sure when I could have, other than some sort of reconsideration attempt or motion for relief from ruling. In other words, a post hoc sort of motion to try and undo what the court had already done. We felt one request was enough. And that said, with 5 minutes, unless there's anything further from the court, I'd like to reserve the remaining time for rebuttal.
That's fine.
Thank you, Your Honor.
May it please the court. Counsel, my name is James F. Weiss. I'm the attorney for the appellee, Marina SACHS, who's also present in the courtroom. I will not reiterate what's found in the briefs. I will address only the matters that are raised as kind of ancillary issues or elaborations upon what's in the briefs by the appellant here. First of all, with regard to the standard, these parties agreed to proceed in the fashion that they did. No request that I can find was made for an evidentiary hearing. I just took another look at the opening brief. I didn't bring the reply brief or didn't find it in time to direct your attention to that. But I didn't find anything requesting an evidentiary hearing. As a matter of fact, what these parties did, and this is record item number 27, a stipulate to vacate an evidentiary hearing. There had been an evidentiary hearing set before the court on March 18, 2014 at 1:30 p.m. In the stipulation, the parties said that the hearing on that date should be vacated in its entirety in the interest of preserving judicial resources, as the parties have reached an agreement on the issue of the validity of the prenuptial agreement, which I understand to be, we figured out a way to present this to Your Honor. And what they did was prepare a briefing schedule. Now, counsel suggests that 20 days wasn't quite enough, and they weren't really sure about the standard. However, the record is also complete with references to stipulations to extend the briefing schedule, because what they did is they had a mediation in between when the order came out to allow this to be briefed, and they wanted to mediate the issue, and then when they stipulated to extend that schedule, and then they came back after the mediation failed. The petition, of course, was in August. The first brief wasn't until April. Appellant had all of that time to develop whatever testimony he wanted. There was no reference in any of the orders scheduling a hearing limiting what could be presented to the court. In other words, if there was expert testimony to be presented to the court, it certainly could have been done in the briefs.
I guess the problem I have is the expert testimony even needed? You could read O'Daniel so broadly as to vitiate most prenuptial agreements because one can almost assume that we will all fall into a position at some point in the future as bad as the wife in O'Daniel.
And if that's the case, Your Honor, it would tend to mean that, just your point earlier, that almost no agreement could be enforced, and yet Tennessee has.
We're not responsible for what the Tennessee courts do, but this is what they did.
Understood, Your Honor. And, of course, it's in a case in which the focus is on the party being deprived of spousal maintenance, and that's what this prenuptial did. And it's probably worth noting that a father, in challenging the validity of the prenup, what is he really asking this court to do? Blue pencil it out? Because he wants to enforce the provision that says, if you don't get any spousal maintenance if we get a divorce. And even if he's trying to educate or make the argument that no prenup could be valid, it would go directly contrary to his own responses. In his resolution management conference statement, for example,
Let's talk about O'Daniel, though, some more. I mean, give me your reading of O'Daniel that is most charitable to your position. Because, I mean, I admit it seems like an odd case, but you agree it controls, right?
It's part of the Tennessee law, and I don't pretend in a minute, Your Honor, to have a full understanding of the full bevy of Tennessee decisions upon this. It's placed within a context of a statutory framework that certainly presumes the validity of an agreement, which intends that people are bound by what they read and execute, and which
That's sort of the Arizona view. That's our understanding. But as I read O'Daniel, it casts doubt on that being the norm in Tennessee.
Well, if it's looking at what happens in the future, it does seem, even if it casts some doubt on the validity of, I don't read it to say all prenups are invalid.
Well, where do you find the most solace in O'Daniel?
That they took a look at what is the evidence that's going to be presented to the court that would relate to rendering somebody a public charge in the event the agreement is rendered invalid. And if that's the case, then certainly it's incumbent upon the person, because we start with the statutory proposition, they're presumed to be binding. O'Daniel is therefore an exception to the statute. When we're trying to prove an exception to the statute, upon whom does the burden cast? That would be on the person that's trying to contest the validity of the agreement in the first place. No matter what O'Daniel says, I would remind the court that Father took the position this is a valid agreement. He insisted upon its performance, except he wanted a blue pencil reformation of what he found the one part he didn't like, because he contended I didn't have a good chance to read it. So if O'Daniel's is the exception and we place the burden upon the party contesting validity and we ignore the fact that he said this is a valid agreement, if we go through all those steps, then it's still incumbent upon somebody to present some sort of evidence rather than simply the speculation that maybe 10 years from now I'll be a public charge on the public dole, whatever that might be, even though I'm benefiting from that right now because I receive Social Security disability income and the insurance that's provided, and 10 years from now I'm going to lose my private disability payment. That's his complaint.
That sounds even less speculative than the evidence in O'Daniel. You have a 33-year-old woman who seems to have the ability to go on and have an economically productive life, but the court, by my reading, speculated pretty heavily to find public charge, which I mean, this is probably not an opinion I would have written. It doesn't leave a lot of room for enforcement, but do you see my concern?
I do, Your Honor. I think. And the question is, if O'Daniel took that position and almost the universal cast of characters which might appear before the court could be in that same position, why not just invalidate all prenups? But that's not what happened. And so I would rely on the fact that perhaps that's an aberrant reading and the court did engage in some speculation, but we still have the Tennessee statutory standard and other cases which have found the agreements to be enforced, and it all
Does the statutory standard mention the public charge issue?
I don't believe so, Your Honor.
That's just a judicially created exception.
I believe it is.
Okay.
In any event, we believe that even in O'Daniel, someone had to come forward with evidence. And if the standard is, if one is to be rendered a public charge, then it was incumbent upon the appellant here to present that evidence. He had from April going backwards in time to August to develop that. He actually cited to O'Daniel in the opening brief, meaning he was advised, here's the evidence I needed to present. And then when he presented that to the court, Judge Porter, we believe, appropriately found that, look, you are not going to be made a public charge. In fact, he is not today. In fact, he continues to hire private counsel and pay him. In fact, he filed a post, you can determine from the case history, the docket, and the underlying action. He's even filed more pleadings in that and made some of the same arguments, but none of those arguments contain, I've been rendered too poor to do anything. So we believe that the public charge simply is not an abuse of discretion as found by the court. That was the standard because these parties equipped Judge Porter with the ability to make a ruling based upon whatever they chose to present, and they simply did not come forward with convincing enough evidence, and therefore the ruling should be affirmed. I have no further comments unless the court has additional questions.
All right, thank you.
Thank you very much.
Thank you very much, Your Honor, for this chance to present a little bit of rebuttal argument, and naturally I'll contain my comments to what was discussed by Mr. Weiss. Now, I do want to do a little bit of clearing up the record here when he did mention quite accurately that there was an evidentiary hearing and it was vacated. That is true. However, I think the record makes it very clear that that evidentiary hearing was to determine the basic genuineness of the prenup. In our answer, our very first document filed, we actually contested the addendum that contains this provision with the cash payout. My client sincerely did not believe he signed any document that contained the cash payout provision. We requested in discovery to get a signed copy that actually showed him that he signed such a thing, and sure enough, in March, they did present a signed copy. Now, once we received that copy, we dropped any contest as to the genuineness of the prenuptial agreement. That is why that evidentiary hearing was dropped, and then the question became whether or not it was enforceable. And we just went through that earlier. Then the trial judge set the briefing schedule. I did notice a bit of hostility with respect to the O'Daniel ruling, and I can certainly understand that. That may not be Arizona's way, but the parties did agree to go with Tennessee's way. In fact, the O'Daniel case had already been decided by that time. And that said, maybe it's not the best way, maybe it's not the most ideal way to handle things, but it looks like what O'Daniel is recommending is put a full and fair contest, including all that. I'm sorry, Your Honor.
I don't know if by hostility you're referring to this bench, but let me ask you, our duty is to apply Tennessee law to determine enforceability. The Tennessee legislature has spoken on the subject, and there is one case that engages in some fairly dramatic economic speculation that was decided in the context of a waiver of what they call alimony.
That's correct, Your Honor.
And it seems that to underlie O'Daniel that there is a pretty heavy presumption in favor of alimony in Tennessee, which there is not in Arizona. The context is different. The case is a single case, and our job is to determine what Tennessee law is, not merely to follow the most recent decision of an intermediate court of appeals in another state. How do you reconcile O'Daniel with the Tennessee statutory scheme?
Several ways, and some more perhaps persuasive than others. One, there was obviously a chance for the litigants in that case to present it to a higher court and make the same argument that the Tennessee legislature has spoken, the code citation that's presented by Mr. Weiss, and as such, this exception therefore should not apply. That didn't happen. A second reason, again, maybe not too persuasive, but we've heard of legislative abrogation. If the legislature would have found this particular case to be abhorrent to the principles it used when it decided and wrote the law, it would have, as it has done many times, maybe not in Tennessee, but in other places, it would have distinguished circumstances such as O'Daniel, so that the public charge exception could not apply. So the fact that these steps didn't occur leaves, I think, lawyers in the perhaps unfortunate position that they just have to assume it's good law. And as such, and I don't think it is that bad of law just to recommend. All O'Daniel really did is say, let's have a full and fair contest. And admittedly, it's one of those things that in the end, a trial court is going to have to engage in some level of speculation. But that happens all the time. And it's not ideal. And we believe that has to happen in a case like this, that we need the opportunity to fully and fairly present our full evidence, not 20 days. And I would point out that that's all we had. We didn't have all that time he was talking about to develop this evidence. 20 days, it's apparent from the record, to do this brief. And finally, with respect to another point he brought up, it sounds like the appellee is suggesting that we should have asked more times for the court to entertain the notion of an evidentiary hearing. We asked, the court had a very, admittedly, it seemed like a clean way by resolving conflicting inferences in our favor to avoid it, but it ignored, we believe, the right side of the equation, which is where we believe we would have prevailed, but we were prevented from presenting that. That said, my time has expired, Your Honor, unless there are further questions.
Thank you very much.
Thank you.
Matter is now under advisement. The court will issue a written decision in due course. We will stand in recess for a time to allow the next matter to set up. Thank you.